I'm Captain Derek Stewart with the Tennessee Highway Patrol. Citizens of this state have the right to keep and to bear arms for their common defense. In 1996, the Tennessee General Assembly enacted the Department of Safety approved Handgun Safety Program. The purpose of the program is to establish uniform, statewide minimum standards for the certification of handgun safety schools and instructors for civilian individuals or non-police. This video is intended to provide information on Tennessee firearm carry laws by providing a framework for the necessary requirements for the use of deadly force in Tennessee and familiarize you with the personal liability you assume for negligent acts with a handgun. You will have a clear understanding of all restrictions placed on individuals who wish to carry a handgun in Tennessee. The Department of Safety is charged with the issuance of handgun permits to persons who are lawfully permitted to obtain a handgun permit under state and federal law. The department works with the Federal Bureau of Investigation, the Tennessee Bureau of Investigations, and your local sheriff's department to ensure the integrity of the program.
Basic requirements to become a handgun permit holder in the state of Tennessee. You must be at least 21 years of age. Provide proof that you are a United States citizen or that you have lawful permanent residency in this country. You cannot be a convicted felon or currently under indictment for a felony. You cannot have committed the crime of domestic violence, stalking, or had a dishonorably bad conduct discharge from the military. You cannot currently be under jurisdiction of the court for any Class A misdemeanor. You must successfully complete the 8-hour handgun safety course you are taking today. This certificate will be good for 6 months from the date of the class. Once it expires, you will be required to complete a new class. If you meet the basic requirements, the next step in order to obtain a handgun carry permit is to take the following information to any full-service driver license station. Take your proof of citizenship, such as a certified birth certificate, your handgun safety certificate, $115 fee, complete an application, then the examiner will review your paperwork, take your photo, and capture your signature. The examiner will give you a handout with the information on how to be fingerprinted. You must complete your fingerprints within 30 days of applying for your permit. The fee for your fingerprints is included in the cost of your application. The handgun unit will review all your paperwork and complete 3 background checks: local sheriff's agency, TBI, FBI. It usually takes about 90 days, 3 months, to receive your permit in the mail. If any problems are found in your paperwork or background checks, you will be sent a letter advising you what your next steps will be.
A permit to carry a handgun is not a license to use deadly force. This permit is not to be used to enforce the law. It is for self-protection only. If you see a crime in progress, find a safe location, call the police, and try to be a good witness. You are not the police. Do not pull your handgun. A permit to carry a handgun is not a license to carry weapons. It's for a handgun only. Tennessee does not have a weapons permit for knives, batons, tasers, chemical weapons, bats, or swords. Remember, you are responsible for the bullet and your handgun at all times. If you shoot someone, you can be sued in civil court, even if you are not charged with a criminal offense. You are not allowed to have a handgun in your possession anytime you are consuming alcohol or any controlled substance.
Public Chapter 1009 amended our current handgun carry permit law to allow an individual with a handgun carry permit to carry a firearm into a restaurant that serves alcoholic beverages. This is permissible only as long as the handgun permit holder is not consuming alcohol and the establishment does not have a posted prohibition of this act. As a student of this class, you will be instructed on the effects of alcohol and drugs on an individual and how these substances affect your central nervous system. The effects of alcohol and drugs on the body are very broad depending on the type and the amount consumed by the user. Alcohol begins to be absorbed in the bloodstream within 1 to 2 minutes after an alcoholic beverage is consumed. As you consume alcohol, it accumulates in your blood. Intoxication occurs when you drink faster than your liver can oxidize it. Once in the bloodstream, the alcohol is distributed to all parts of the body. When it enters to your liver, it immediately begins to be oxidized. However, the liver can only oxidize about 1 drink an hour. And contrary to many home remedies such as drinking coffee, cold showers, or things such as that, only time can sober a person who has been drinking. Drugs are a little bit harder to define because the effects of drug vary depending on the type and the amount consumed. For example, cannabis type drugs are usually smoked or taken orally in some way. The most common, of course, is marijuana. And let us not forget the significance that secondhand smoke from marijuana contains more cancer-causing agents than tobacco smoke. Inhalants are deeply inhaled and can result in disorientation, violent behavior, unconsciousness, or even death. Stimulants, such as amphetamines and methamphetamines, can be taken orally, injected, or inhaled. Now, these drugs normally can cause increased heart and respiratory rates, elevated blood pressure, dilated pupils, and decreased appetite. In addition to the physical effects, users usually feel restless, anxious, and moody. Depressants, such as barbiturates and tranquilizers, are very similar to the effects of alcohol. Larger doses can cause slurred speech, staggering gait, and altered perception. Hallucinogens interrupt the functions of the neocortex, which is that section of your brain that controls the intellect and keeps all your instincts in check. Users sometimes self-inflict pain to themselves mainly. Now, these are some of the main types and classes of drugs that we are experiencing today, but there's one that I haven't touched on that I want to be very clear about as well. Prescription medication. Prescription medication right now, we are seeing a very large influx of that. Now, prescription medication can be anywhere in your home that people may have bought from somebody. They could be stored in your cabinet. Being mindful that people have access to that, including your family members. But we sure can't lose sight of this because a lot of families are being affected by this, and this is out in the public as well, and the places into these restaurants as well. Our physical makeup is unique and different with each of us. Metabolism rates, body weight, and body fat can all be factors in determining how much alcohol or drugs it takes to raise our BAC or the drug level of drugs in our system. Let's consider the effects at different levels of BAC. For instance, if your blood alcohol level is 0.01 to 0.029, you're going to start being still normal and you're going to be an average individual, but you're going to start noticing subtle effects that can be detected normally with tests. While this is a relatively low BAC, it's beginning to take control of your body and you're going to start feeling the effects of it. At 0.03 to 0.059, you're going to start experiencing mild euphoria, kind of a sense of well-being. You'll start feeling relaxed and you'll be kind of joyful and have a lot of joyousness there. And you'll start being a little more talkative also. Now, as far as impairment at this level, your alertness is starting to be affected, your judgment is starting to be affected, your coordination and your concentration. And beginning at this level, what you're going to start seeing is your reaction time begins to slow. In other words, it's going to take you longer to react to something that happens. At 0.06 to 0.10, you're starting to feel, in your behavior-wise, you're going to have blunted feelings, disinhibition and extroversion. As far as how you can feel the impairment, your reasoning is starting to be questioned. Your depth perception and your peripheral vision and the things that are surrounding you is going to be affected as well. At 0.11 to 0.20, you start having an overexpression. You kind of have emotion swings, and it's easy to get very angry and it's easy to get very sad. And you can also be somewhat boisterous. At this level of impairment, you start to notice your reflexes being affected. Also, your reaction time is considerably slower and it's very marked, and you'll notice that. Staggering, slurred speech takes effect here as well, and your motor controls are very off. At 0.21 to 0.29, it's kind of get to the point of a state of stupor. Loss of understanding, your sensations are very impaired. And as far as your behavior and noticing what's happening to your body, you're going to have severe motor impairment, even loss of consciousness in some people, and your memory is going to be gone. At 0.30 to 0.39, You're going to have severe central nervous system response to this, even depression, unconsciousness, and even possible death. With this level, you're going to start having problems with your bladder and being able to control your functions there. Your breathing and your heart rate is affected. And anything at 0.40 and over, it's just a general lack of behavior, unconsciousness, and even here to the point of death. Your breathing, your heart rate, and even here, you could even possibly lose your life. Now, let's kind of do some comparison as far as the amount of alcohol consumed and kind of what the BAC would be. And we kind of use a standard drink chart for this. In other words, if you're drinking 80 proof liquor and you have 1.5 fluid ounces, there's about 0.6 of alcohol in the fluid ounces in this drink. Beer at a 12-ounce drink has about 0.6 alcohol in fluid ounces. Now, to do that in a way that we understand it, we have to compare the number of drinks compared to your body weight and the approximate BAC that you'll have at any given time. For instance, if you drink one drink and you weigh 100 pounds, your blood alcohol is going to be about 0.04 to 0.05. If you drink two drinks and you weigh 120 pounds, your blood alcohol level is about 0.06 to 0.08. Three drinks and you weigh 140 pounds, 0.08 to 0.10. Four drinks and 160 pounds, about 0.09 to 0.11. Five drinks and 200 pounds is 0.09 to 0.11. So one thing that we have to remember, your body size, and like we talked about earlier, your metabolism rates and how your body absorbs your body fat, all these things are factors that's going to determine what your blood alcohol level is by the number of drinks that you've had. If you violate the provision of Public Chapter 1009 and you were caught in a restaurant that serves alcohol and you were consuming alcohol, the first thing you need to be mindful of is it's a Class A misdemeanor. The next thing you need to be mindful of is that you can lose your handgun permit for a period of 3 years, and it's a mandatory revocation of your handgun permit. We have now discussed the effects of alcohol and drugs and how they alter your reflexes, your judgment, and how it would alter your ability to handle a firearm. You must consider all these possibilities when you choose to enter an establishment that serves alcohol and you're carrying a firearm. Even though you may not be drinking, you may be faced with a situation with someone who is, and you must act appropriately and be able to justify your actions. It's your responsibility to see that guns and alcohol, or guns, alcohol, and/or drugs do not mix. Combined, any of these create a very lethal combination.
Many of you will have questions about how to protect your persons and your property legally. This is covered under the Castle Doctrine. The Castle Doctrine can be found as far back as in the English common law of the 1700s. The modern law basically says that your place of residence is one in which you should be able to protect yourself from illegal trespassing and attack. This law gives you the legal right to use deadly force to defend your home. In legal context, therefore, use of deadly force, which actually results in death, may be defended as justifiable homicide under the Castle Doctrine.
What is the definition of deadly force? It's a force known by you to cause serious bodily injury or death. Let's look at the crimes and the causes of these crimes, or the elements of these, so that you can be aware of when to use your weapon and when you should not use your weapon.
Criminal homicide or murder is the worst of the possible criminal offenses that you could be charged with. Depending on the exact charge, a person convicted of murder can be sentenced anywhere from 2 years to life in prison. A person convicted of first-degree murder can be subject to the death penalty. Criminal homicide charges include first-degree murder, second-degree murder, voluntary manslaughter, criminally negligent homicide, and reckless homicide. First-degree murder is the premeditated and intentional killing of another. Second-degree murder is the knowing and the intentional killing of another without provocation. Voluntary manslaughter is the killing of another in a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Criminally negligent homicide is criminal conduct in which you neglect a duty placed upon you by law and it results in death. Acting negligent with a weapon or acting careless in its handling could impose criminal responsibility upon you. Reckless homicide is taking a life of another person by conduct that any reasonable proven person would know was likely to result in the death of another person. Not within the homicide statutes, but still a serious felony charge, is aggravated assault. Aggravated assault is intentionally knowing or recklessly causing of serious bodily injury to another. Also, intentionally knowing or recklessly causing another to reasonably fear imminent bodily injury by display of a deadly weapon. Examples of this would be to hit someone while holding a weapon in one hand, or hit someone with that weapon, or shooting someone and not killing them, or simply threatening someone while displaying a weapon. You could be held liable for aggravated assault.
Even with a permit, you may not carry your handgun in some places. In addition to criminal charges that you may face, if you use a weapon, you also will need to understand there are criminal charges that can be placed against you for carrying the weapon in the wrong place. It's your responsibility as a permit holder to know the law and to keep up with the changes to the law.
Presently, there are still places you cannot carry your handgun even if you are a permit holder. And they are as follows: a judicial proceeding or courthouses, even though they are not posted. This would be a Class E felony. It is an offense for any person to possess or carry, whether openly or if you conceal it, any firearm not used solely for instructional or school-sanctioned ceremonial purposes in any public or private school building or bus, on any public or private school campus, grounds, recreation area, athletic field, or any other property owned, used, or operated by any Board of Education, school, college, or university Board of Trustees, regents, or directors for the administration of any public or private educational institution. It is not an offense under this subsection for a non-student adult to possess a firearm if the firearm is contained within a private vehicle operated by the adult and is not handled by the adult or any other person acting with the expressed or implied consent of the adult while the vehicle is on school property.
An individual corporation, business entity, or local, state, or federal government entity or agent thereof is authorized to prohibit the possession of weapons by any person otherwise authorized at meetings conducted by or property owned, operated, or managed under the control of the individual, corporation, business entity, or government entity. Notice of the prohibition shall be posted. Posted notices shall be displayed in prominent locations, including all entrances primarily used by the persons entering the building. If the possession of the weapons is also prohibited on the premises as well as within the confines of a building located on the property, the notice shall be posted at all entrances to the premises that are primarily used by persons entering the property. The notice shall be in English, but a notice may also be posted in any language used by patrons, customers, or persons who frequent the place where weapon possession is prohibited. In addition to the sign, notice may also include the international circle and slash symbolizing the prohibition of the item within the circle.
If you are involved in a shooting, remember the acronym CAPS, C-A-P-S. Call the police. As soon as you have been involved in a shooting where you have had to exercise your rights to self-defense, the first thing you want to do is notify the authorities. You're not guilty of anything. Call them, make it clear that you want them to come. Assist the injured. Make sure that the emergency personnel that you contact have medical personnel on the way. Basic first aid should be performed on yourself and others. Place the weapon in a secure location. Do not have it in your hands when the police arrive. Police are trained to react to the sight of a weapon, and they will. If they come up on a scene of a shooting, That might be all the information they have, and they see you standing there with a gun and you could get shot. Secure the scene. Don't allow for alteration or removal of any evidence. There have been cases in shootings where bystanders have stolen weapons or stolen other items of evidence that are essential for the police in reconstructing the crime scene.
Law enforcement stop and detainment. Hand the permit to the officer when you hand them your license. Let the officer know that you are armed and where your weapon is. Do this verbally. Make sure that you do not reach or to attempt to show the gun to the officer. Remember, officers will more than likely not know you. Through their training, they will react to sudden and quick moves because that will put them in fear for their lives. So when you reach for your permit and your license, do it slowly, deliberately, and calmly. Don't make any quick sudden moves like leaning over the glove compartment because the officers will react to sudden moves. Remember that officers are trained to react to the sight of a gun, and they will. When they see one, they will pull their gun more than likely. Understand and know this is not an overreaction. That's what they're trained to do. By letting the officer know up front that you have a valid handgun carry permit and advising the officer where the gun is, then the officer will likely know that you are an upstanding citizen that does not have a criminal background, and the encounter will be easier on all involved. The officer may temporarily disarm you during the conduct of lawful law enforcement activity.
The following are reasons for denial of a permit. The applicant does not meet requirements in Tennessee Code annotated. The applicant did not provide fingerprints as required under Tennessee Code annotated. The applicant did not provide proof of completion of handgun safety school or valid exemption. The following are reasons for suspensions and revocations. If you have been arrested and charged with burglary, felony drug offense, or felony offense involving violence or use of a firearm, you will be suspended until final disposition of the charge. If you have been arrested and charged with any other felony, the holder has a right to a hearing before court having first jurisdiction before suspension. If you have been arrested and charged with domestic violence, stalking, DUI, second offense, if you are prohibited from purchasing or possessing a firearm under federal or state law, if you have been convicted of a felony, if you have been convicted of any Class A misdemeanor and under court jurisdiction presently. Federal and state law prohibits possession of a weapon or permit by someone convicted of a misdemeanor crime of domestic violence. Domestic violence is defined as a crime of violence against a person within a defined domestic relationship. It does not have to be charged or convicted of domestic assault. You can be convicted of assault and the victim can be the spouse, significant other, or child of offender. If your rights have been restored, there are still convictions which are exempted, which will prevent you from obtaining a handgun permit. They include burglary, felony offense involving violence or use of a firearm, felony drug offense involving a Schedule 1, 2, 3, 4, or 5 controlled substance, felony drug offense involving a Schedule 6 substance if that conviction is within 10 years of application or renewal of a permit. Federal law on possession of a firearm may prohibit a person with a restoration from obtaining a handgun or a permit. Tennessee has reciprocity agreements with other states concerning your handgun carry permit responsibilities. However, it's your responsibility as a permit holder to contact any state that you will be traveling through to verify that they will honor your carry permit and what the laws are in each state that you will be traveling through.
Americans enjoy a right that citizens of many other countries do not, the right to own firearms. But with this right comes responsibilities. It is the gun owner's responsibility to store, operate, and maintain his or her firearms safely. It is the gun owner's responsibility to ensure that unauthorized or untrained individuals cannot gain access to his or her firearms. It is the gun owner's responsibility to learn and obey all applicable laws that pertain to the purchase, possession, and the use of firearms in his or her locale. Guns are neither safe nor unsafe by themselves. When gun owners learn and practice responsible gun ownership, guns are safe. A permit to carry a handgun is not a license to use deadly force. With a permit to carry a handgun comes an awesome responsibility. You are legally and financially responsible for the bullet and the damage that is done.